Divorce litigation is not therapy. Divorce is emotional, litigation is procedural. Confusing those two things needlessly causes serious problems. Many people enter court believing that if they fully explain their emotional pain, the judge will compensate them for it in the form of a punitive child custody and/or financial award. That is rarely how it works. Judges filter for relevance. They look for evidence that ties directly to statutory and case law criteria. Statements like, "He ruined our marriage," or "She destroyed our family," may be emotionally accurate. They are not legal arguments, however, unless connected to parenting capacity or financial misconduct. Oversharing can undermine credibility. Emotional monologues untethered to statutory analysis may appear unhinged or vindictive. Courts evaluate how parents regulate and manage their emotions, not whether they simply feel them. Emotional stability itself is a factor considered in making the child custody award. Judges ask, can this parent regulate himself? Can she make decisions calmly? Can these parents prioritize the children's needs over their own anger? Therapy can be helpful in going through a divorce. Support systems are crucial. These are both out-of-court helps, however. Court is different. Court structures life after divorce. It does not exist to heal psychological wounds. When litigants use hearings and trial for emotional catharsis, they often escalate minor disputes, file unnecessary motions, and appear consumed by grievance and vengeance. That rarely produces better outcomes and often results in worsening them. Emotional discipline is case-protecting, case-strengthening discipline. The litigant who remains measured, concise, and statute-focused usually advances his or her position more effectively than the litigant seeking validation. I do not minimize the reality that divorce is painful and in so many different ways. But litigation results turn on legal merits, not on your feelings. Family court is not therapy. It is a deliberative and adjudicative process governed by statutes, rules of evidence, and burdens of proof. It exists to resolve defined legal disputes, not to validate emotions or referee moral grievances. Understanding that difference makes you more effective. Understanding that difference makes you more effective in the way you prepare and present your case.